Um, Hi, Jeff. Are you here, Jeff?
Welcome, Delanor.
Okay. Jeff, thank you for making this possible for me as a technician for this presentation. Without you, I would not be able to do anything. So you are keeping the slide for me and we'll work together. My name is Delano Ulis. I have the pleasure to uh, make this legal presentation today, legal training today on unemployment. Um, I have been with the program for over 40 years now in both programs, legal aid and coast-to-coast legal aid. So, but unemployment, that's what I do during the time, most of the time I worked for the programs. And as a way of disclaimer, before we start this presentation, I would like to let you know we don't intend to provide any specific legal advice. That is not the purpose of this presentation. Information in today's presentation is current as of August 18, 2022, and this PowerPoint may not be reproduced, distributed, copied, or cited in whole or in part without coast-to-coast legal aid of South Florida's written permission. For more information, please visit our website at www.coast-to-coastlegalaid.org or call 954-736-2400. This presentation will not address exception to unemployment law that occurred during the COVID-19 pandemic. Move on to the next. Thank you, Jeff. Florida unemployment insurance program is called Reemployment Assistance. This may be written also as UIUC or RA. It was back in 2011 that Florida has changed the name, but people still go by usually unemployment. When they say unemployment, we know what they mean. If an employee loses their job, was put on a furlough, or had hours reduced through no fault of their own, they can put in an online application and connect to receive monetary assistance and help finding work. I would like to remind everybody that unemployment is not entitlement in a way it is for food stamp and SSI for Social Security. This is based on working. The Department of Economic Opportunity, so-called DEO, is the state agency responsible for administering the RA program, Reemployment Assistance Program. DEO also administers Career Source, where workers can obtain assistance finding employment. Funding for the program comes from the state and from employer contribution. Employees do not contribute to unemployment to their wages. This is a myth that people would say, well, I have worked all my life and now I cannot get unemployment. The unemployment does not have anything to do with returning any portion of your wage for unemployment. This is paid by your employer through taxes. Move on to the next slide. The weekly payment amount will vary depending on prior work earnings and current hourly wages. So you cannot compare yours with somebody else unless you know everything pertaining to how much the person worked in the base period. The maximum weekly benefits amount for anyone in Florida is $275 over a maximum period of 12 weeks. The total maximum benefit amount is $3,300. It does not matter whether you were a lawyer, medical doctor, or whatever. You cannot get more than $275. So don't fight because you made so much working for your employer and you get only $275. It's set by the law and you cannot get more than that. Benefits extension may be provided by the state during periods of disasters or higher unemployment. Check the DEO website for information on additional Florida unemployment benefits. Next. The claimants are the people who applied. I would say the applicants. So for the purpose of unemployment, the name is claimant. If you are a claimant or you are an employer. So the claimant will need the following information when filing a claim for unemployment. you have to have a social security number. No one can get unemployment unless you get a social security number. You have to have a driver license or state ID number. Information on the last 18 months of employment, including employer names, addresses, and phone numbers, date of first and last day of work. You don't have to be scientific about that. Sometimes they need to have the best guess that you can have if you don't remember exactly the date, but you have to put a date for the computer to allow you to move on. Gross earnings before deductions, reason for separation from the employment. The reason can be multiple, so you have to be careful what reason you put. You can self-incriminate yourself if you put things that should not be put. Be careful when you choose the reason for separation. Make sure that you know what you're putting down. A FEIN number found on your W-2 or 1099 tax forms. However, the FEIN number may be searched for and connect by using the employer details from the pay stub. It's very funny that people sometimes they don't know who is their employer. Usually the employer is the name of the company who is in your pay stub, because you may be working as for a leasing company, and you work at a specific local place, but this place where you work is not really your employer. You have to check on your pay stub to see what name is there, and that's the name of your employer, not the place necessarily where you work. Some workers, military employees, federal employees, union members will need to provide additional information. See the EO website for more details. Next. Filing a claim and connect. There is no other way now to apply for unemployment except to use Connect. Within 1 week of becoming unemployed, the claimant should file for Reemployment Assistance or a benefits. The date the application is submitted determines the date of benefit payment. If you lost your job 2 months ago, 3 months ago, 4 months ago, and you waited to apply, it will go with the date you apply, not the date you lost your job. The process to submit the claim may take an hour to complete. The week the claim is filed is considered a waiting week, and no payments are made for that week. So this waiting week will be paid at the end of the claim. Remember, we told you earlier that you have 12 weeks. So this waiting week will be the 12th week at the end. Meaning if you find a job, you don't get there, you're not going to get this week. It's not a week that the payment is already paid to you. You have to wait for the last week to get this waiting week. Only claimants who are legally prohibited from using a computer, have an impairment that makes them unable to use a computer, or are unable to read or write, are allowed to file their claims by phone or mail. This is an exception. So if you are one of those who can file because you have an exception, you need to contact DEO and make your case and let them know that you need to be allowed to get your claim filed by phone or mail. Otherwise, you have to go through filing and connect. Claimants are required to complete work registration consisting of resume type information. And before a claimant can file a claim and connect, they will have to register with IDME. Go back to work registration. You may be given an exemption for work registration if you make the request, because some people they don't have enough knowledge to use the computer to make the work registration. But within 2 weeks of your application for unemployment, if you need to make the request, you have to do that before you file. You make the first report for work search. So you need to do that before that, otherwise you will be disqualified and you would have to file an appeal to deal with that. So it's very important. If you cannot do it, reach out to unemployment and let them know that you cannot do it. Before a claimant can file a claim and connect, they will have to register with IDME. Next slide. The IDME is a new system that they put in place after, I would say, September 4th, 2021. And there is no other way for you to be able to access the computer and connect except to register with IDME. If you have any problem with that, you can always contact the nearest career source in your area. They will help you with that. So you need to be able to access Connect to request or claim your weekly payment every 2 weeks, bi-weekly. The system Connect will always let you know in advance what is your next date to claim and what will be the expiration date if you don't do that. Remember, if you let it go, you don't claim, you are not going to get paid for the weeks you did not claim, but they will still be there in your balance that you can get them ahead, forward, but not backward. A link is provided in Connect which leads claimants to question which must be answered on the penalty of perjury. Earnings. The claimant must report any hours worked during the week and questions and the hourly pay for this week, for this work. Earning must be reported for the week the work was performed, not the week the pay was received. Meaning if you started a job, let's say this past Monday, and you need to claim, so you cannot claim this week anymore unless you have less than the weekly benefits that you are collecting. Otherwise, you will have what they call overpayment because you will not be qualified to receive money as of the date you're working. So it's not the date you get your paycheck, it's the date that you start the job. Even if they will pay you within 2 weeks, but you count the date you started the job. Able and available for work. Claimants must attest to being able and available for suitable work during the week being requested. If you claim that you cannot work, you are not available to work, that you are ill, you are in the hospital, unemployment is not for you because you must be able and available for work in order for you to collect unemployment. You don't confuse unemployment with Social Security disability. So that may be an issue. If you cannot work and you try to apply for unemployment, you will be denied. Refusal of work. Claimant must report any work offered and refused during the week being requested. If work is refused, it is likely that no benefits will be received that week or ongoing unless the claimant can show that the work was not suitable. Next, yes, thank you. Claimant must generally, when you put your work search, you are required to complete a weekly work search questionnaire and Connect. And you have to have at least 5 work contacts that you provide for each week benefits you request. People sometimes put 4 or 3, that is insufficient. You will not get any money for that because it has to be at least 5. If you put more than 5, the computer will not stop you, but there is no reason for you to put more than 5 because that's the minimum requirement. Information to be collected. You have to put the date of contact with potential employer or business, job fair, etc. Method of contact. You can visit a business in person. If that's what you do, you have to provide the name of the business, the telephone number, and complete address of the business. If you use the website, you have to put what they call the website URL that you visited to complete the work search. Usually, it's okay to go with .com. Let's say the place you contacted is let's say it's Coast to Coast Legal Aid, and you say coasttocoastlegalaid.com. Even if you don't put www, that will be okay. Email communication, provide a copy of the email sent or received verifying the work search. Result of the search, you have to say what was the outcome. You have choices like not hired, no response, waiting for call. So you pick up the one that is related to your situation. Type of work you search, field of the industry, what kind of job were you looking for? If you don't put anything, the computer will not let you move on. You have to say what kind of job you were looking for. If it's dishwasher, if it's a maid, if it's a lawyer, if it's whatever it is, you have to put down something in the field given for that. Also, you can meet with a Career Source Florida representative in the local office that will satisfy for work search requirement for this particular week. It's good that if you go to your Career Source nearest to you, you will be able to count this as one week work search, per visit. If you go in the month, during the month, you go twice to the Career Source, so you have already 10 jobs given to you. Instead of putting 10 in the computer, you can put only one for each week, one contact with Career Source for each week, and that will be sufficient. Okay, next. DEO decided eligibility in 2 steps. There are 2 ways that the DEO will let you know if you are qualified or eligible to receive money. The first one is monetary eligibility. I told you sometimes before when I started the presentation that unemployment is not entitlement. So you have to work in order to collect unemployment. So that's why the DEO will determine your monetary eligibility, whether there is money to pay you. And the other one is non-monetary eligibility. Move on. The DEO provides claimants with a monetary determination on a form entitled Wage Transcript and Determination. This must be provided within 2 weeks of the application. To be monetary eligible, claimants must have worked in ensured or covered employment and earn enough wage credit during the base period. This is complicated when we talk about base period, but they will determine that, and they will always give you a chance to appeal it, to fight it. If you don't think that they put enough work that you earn, you can always appeal that and make your case. And independent contractors, because independent contractors are not employees, they are not eligible for benefits. However, employers may misclassify a worker as an independent contractor. It's important to deal with that, and I have several cases throughout the years that the employer would say to the employee, we consider you as independent contractor and we don't take tax from your paycheck. It turned out that is not true, because there are criteria to determine whether the person is independent contractor or not. So if you have a situation where you doubt about that, you have to look for help, because it's not always absolutely true that you are an independent contractor. Next. Claimant must request reconsideration and then appeal of a monetary denial within 20 days from the date the determination was mailed or delivered. It's very important. There are 2 concepts here: reconsideration and appeal. There are 2 different steps. Once the DEO is telling you that there is no money in the base period to pay you, either because the employer claimed that you are an independent contractor, or because you don't meet the threshold of $2,400, the minimum you have to have in the base period to collect money, then once that happens, DEO will issue a notice of determination saying like that you are not monetarily eligible. So in that case, what you do, if you have proof that you work more than what they said you worked for, if you have proof of your 1099 and you can fight that you are not an independent contractor, you have to make a request for reconsideration, and that can be done straight from the computer, from Connect. You can put your wage, you can modify, you can put what is missing there, and they're going to make a reconsideration. And if at the reconsideration, they still find that you are not qualified, then you move on to the appeal of the monetary denial. But remember, you have 2 steps to do that. First, reconsideration, which is not an appeal. It's a request to modify what was in the base period so that you can become qualified if it's possible. And after that, if that does not work, then you move on to the appeal of the monetary determination denied. Next. Some examples of non-monetary issues are quitting, abandoning your job without a good reason, being fired for misconduct, not accepting an offer for suitable work. All of those, you may have money in the base period. So you have enough money to collect, but yet you have issues that prevent you from getting the money because those issues disqualified you. And if you don't agree with this determination that this qualified you, the next step for you is to fight it, to appeal it. Move on. Once the claim is submitted, the employer receives notice and an opportunity to object. The adjudicator determines whether the separation from employment meets the criteria for RA benefits. The adjudicator sends the parties' determination. The adjudication office is very powerful because that's where everything starts, whether you get it or not. If the adjudication office find that you are not eligible due to separation issue with your employer, then it is your turn, it is you to appeal. So, but on the other hand, if they find you qualified to receive benefits, it is the employer to appeal. So that means they have the power to decide one way or another at this very beginning, depending on the information that they collect. An unfavorable determination must be appealed within 20 days from the date of the notice of its receipt. You can appeal in Connect, by US mail, by fax, and by email. No appeal by phone. Something here I would like to clarify for you. When you file your application, DEO will ask you what option do you choose to receive your mail. Now, if you choose electronic, the burden is on you to always know what is happening in your case. But if you choose US mail, the burden is on employment to show that you receive whatever they claim they sent to you. So myself, I always advise people who comes into contact with me that the best way to do it is US mail. So you cannot appeal anything by phone. And if you miss it within the 20 days, you have an issue of timeliness because you have only 20 days to do it. Now, if you choose to receive your mail, US mail, whenever you become aware of it, that's when you appeal it. But if it's at the computer, then you have a harder time to make a case of timeliness because it is your responsibility to look and see when it was posted. If a claimant gets an unfavorable decision, the claimant must continue to claim their weeks while the appeal is pending. And I know that some people, they are claiming weeks for 12 weeks and there is no money. And they stop maybe after 7 weeks claiming or 6 weeks claiming, they stop. But guess what? If you win your case on appeal, then all the weeks you did not claim, they don't pay you that back. You can get it forward until the claim expires. So it is to your best interest to continue claiming even though there is no money, but at least when you win the case, you're going to have your money. I have a case right now that the person did not claim, and there are 19 weeks that she could have received money for after she won the case, but I'm still fighting now to put the weeks in for her because she did not claim them. If the employer appeals a favorable decision, the claimant can get payments while the appeal is pending. If the employer appeals, the claimant must participate in the hearing. Don't think that you get a hearing and you want it, and because you want it, it's over. the employer has the same right to appeal that you have. So if the employer filed an appeal because you won the case and you don't participate, most likely they will reverse the decision, and your disqualification will taken away from you. Once the claims is submitted, the employer received notice. I think we covered that. You can move on, Jeff. Upon appeal, a telephone hearing is scheduled with a referee. Well, people think that the referee is a judge. He's acting as a judge for real, but he's not a judge. He's just, as the name says, that he's a referee. But you give him the same respect you will give to somebody in the courtroom. When he conducts a hearing, and he or she is the one who is responsible. You cannot talk over the referee. You have to respect the rules of the hearing. Otherwise, the referee may give you a hard time at the hearing. If the referee denies the case, both parties have 20 days to file an appeal with the RAC. RAC is Reemployment Assistance Appeals Commission. That is the agency that is overseeing the decision of the referees, and you cannot have any new testimony once your case is filed with Reemployment Assistance Commission. So you have to put your best, do your best at the level of the referee so that you can have a good case, because anything you miss will not be able to put in back, because all the RAC will do is to review what happened in the lower level. An unfavorable RAC decision can be appealed to the District Court of Appeal. So if you still lose at the level of the Reemployment Appeal Commission, the next step will be to file with one of the District Court of Appeal in Florida. Next. Okay, so we did good with our time. Now, if you want to get our service here at Coast to Coast Legal Aid, you can call us at 954-736-2490, or you can apply directly online at www.coasttocoastlegalaid.org/get-help. It was a pleasure to be your presenter today for this unemployment training. Jeff, I think you did a very good job. And until we meet again, I wish everybody a very safe and happy end of day. Thank you.